Good morning, everyone. My name is Kristen Mon. I am the housing coordinator for the City of Tulsa. As the housing coordinator, my role is focused on implementing the citywide housing strategy with a focus on preventing displacement and homelessness in our community. With COVID-19, we are focused on implementing strategies to prevent displacement and address the financial harm caused by COVID-19 to both landlords and tenants. I'd like to briefly tell you about one of the resources currently available to prevent displacement, the Early Settlement Mediation Program. It is a free program sponsored by Tulsa County and the Oklahoma Supreme Court. The Early Settlement Mediation Program provides free mediation to resolve disagreements between landlords and tenants, including difficulty paying rent and disputes over repairs and other maintenance issues. A mediation is a meeting between a neutral third party to help the tenant and the landlord resolve their disputes and come to an agreement that will benefit both of them. Both landlords and tenants are encouraged to apply to this free program as soon as the dispute develops. You can apply by calling 918-596-7786. More information is also available on the Away Home for Tulsa website, awh4t.org/COVID-19-resources. For our presentation today, our goal is to provide information to landlords, property managers, and community partners on landlords' rights and responsibilities under state and federal law, especially during this unprecedented time. This is the beginning of what I hope will be an ongoing conversation. As a brief overview of how today's presentation will go, the first presenter is Alyssa Weber of Homebase. She will explain the CARES Act, including the Eviction Moratorium and mortgage forbearance provisions. The second presenters are attorneys Kelly Knope and Blaine Frierson. They will explain the Oklahoma Eviction Moratorium, as well as landlords' rights and obligations under Oklahoma law. After each presentation, there will be an opportunity for questions. To ask a question, please use the chat feature in Zoom. Everyone is currently muted, so the chat function will be the method by which we take questions. Thank you everyone for attending today, and I will turn it over to Alyssa.
Great, thank you, Kristen. I'm gonna put my slides up. Okay, I think everybody can see my slides now. As Kristen said, my name is Alyssa Weber, and I work for an organization called Homebase. We are a nonprofit based in San Francisco, and we work with communities on issues related to housing and homelessness. Today, I'm here to cover provisions in the Federal CARES Act that may apply to you as property owners and landlords. On March 27, 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. The larger CARES Act includes $330 billion in new funding to address the needs of American people as we confront the coronavirus pandemic, but it also includes a few provisions that may affect you as property owners or landlords. I will go into these in more detail during the presentation, but here's a brief overview of what I will be talking about. The first thing we'll talk about is the 120-day moratorium on certain evictions. So we're starting with the way the CARES Act places some restrictions on the recourse that landlords typically have at their disposal. I know you may be wondering why you are not able to evict tenants for non-payment of rent since you have to pay your bills too. This moratorium is very important and in the best interest of communities from a public health standpoint. I believe that is why it is in here. The only way to enable proper social distancing is to ensure that people are in homes of their own. And as the economy continues to struggle over the course of this pandemic, we have to assume that there will be a spike in the need for our crisis response system. The best way to keep people from needing the crisis response system is to keep them housed to begin with. That being said, the CARES Act does provide some additional support for homeowners and landlords. One is through additional funding to prevent evictions and loss of housing. This is mostly in place to assist tenants in maintaining their current housing or quickly find new housing. And I will go over a few of those as they relate to homeless assistance and prevention. There's also the opportunity for a mortgage forbearance for certain properties. Those with federally backed loans who are also experiencing financial hardship due to the COVID-19 pandemic. And finally, there's a 60-day moratorium on foreclosures and related evictions for certain types of properties. So now I'll just go into each of these in a bit more detail. We'll start with the eviction moratorium. This is covered by Section 4024 of the CARES Act. And as I mentioned, is in effect for 120 days, so will be in place until July 25th, 2020. The eviction moratorium restricts those with mortgages on covered properties. And I'll talk a little bit more about what a covered property is in the next slide. And the moratorium restricts landowners from those covered properties from filing new eviction actions on non-payment of rent, charging fees, penalties, or other charges to the tenant related to non-payment of rent, or evicting a tenant after the moratorium expires, except on 30 days notice given after the moratorium period. So you cannot require a tenant to vacate the unit before 30 days after a notice to vacate, and that notice to vacate cannot be issued prior to July 25th. This moratorium applies regardless of whether the tenant has a valid lease for the unit. So even in units without a lease or with a lease that is terminable under state law, the moratorium still applies. So what properties are covered by the CARES Act? The Act defines a covered property as properties that participate in what is a covered housing program defined by the Violence Against Women Act, or VAWA, and a property that participates in the Rural Housing Voucher Program, a property that has a federally backed single-family mortgage loan, and those are defined as loans for 1 to 4 units, or a property that has a federally backed multifamily mortgage loan, so those with 5 or more units. So I'll talk a little bit more about each of these categories so you can try to figure out if the properties that you own actually are covered by this act. So as I mentioned, the eviction moratorium extends to federal housing rental programs covered by the VAWA Act. Essentially, using this was a way for Congress to extend coverage to most federally assisted rental housing programs. And you can see how many types of housing fall under that. Basically, the first 3 rows of this slide are covered under VAWA. So you'll see the McKinney-Vento Act program, so COC and ESG programs fall under this category. So does public housing. So Section 8 housing choice vouchers, Section 8 project-based housing are also under this. And the low-income housing tax credit is also included as a VAWA property. There's also the properties that participate in the Rural Housing Voucher Program. So those are where landlords accepted rural development vouchers through the USDA. And then the last 2 categories here are quite broad categories as well. Any loan made in whole or in part, insured, guaranteed, supplemented, or assisted in any way by an officer or agency of the federal government. So this applies to loans through HUD, the VA, USDA, or owned by Fannie Mae and Freddie Mac. So as I mentioned, the Act distinguishes between the single family 1 to 4 units and the multifamily 5 or more units, which isn't as relevant for the eviction moratorium, but will become more important when we get into the forbearance provisions later. So how can you find out whether your property is covered? You might not know. There are a few places that you can look to determine whether your property is considered a covered property that we just discussed. So first, you can check your loan documents, such as your mortgage instruments, your records from your real estate closings, your loan servicing notices, account statements, or other correspondence. If you can't tell from those or you don't have them available, you can contact your mortgage servicer. They are required to tell you who owns your mortgage and provide you with the contact information for whoever owns your mortgage. There are also a few databases that might help you look up whether or not your property is covered. These are links here in the slides. You can also Google these, but we will send these slides out and you can click on those links to access these. So the first one listed here is Fannie Mae and Freddie Mac both have loan lookup tools. You can, when you go to these, you input some information such as your name, address, social security number, and it will tell you whether or not Fannie Mae or Freddie Mac own your loan. There's also the National Housing Preservation Database, and this is an inventory of properties assisted by federal rental subsidies across the country. You do have to register to access this database, but it is free if you're working as an individual. It includes a lot of the housing programs, but not all of them. So the housing programs that are included are public housing, project-based Section 8, supportive housing for the elderly, supportive housing for persons with disabilities, the low-income housing tax credits, Section 236 preservation program, the home investment partnerships, mortgages insured by the Federal Housing Administration, and mortgages insured by USDA. So if you go to this database and you look up your property, if it appears in the database and has the property status of active, your property is considered covered by the Act. There's also a spreadsheet that HUD has, the HUD Insured Multifamily Mortgages Database, and this is a spreadsheet of all active HUD multifamily insured mortgages, which was last updated on March 31st, 2020. So you can go to that and look in that spreadsheet to see if your property is listed. There may be a few housing types that are not captured in your loan documents or in these databases. So we've listed a few options here for agencies that you might be able to contact to figure out whether you are a covered property. So for Section 8 housing choice vouchers and HOPWA, you can contact your local public housing authority. For the McKinney-Vento assistance grants, so those continuum of care and emergency solutions grants, you can contact your local continuum of care. And for both of these, you may be able to determine whether they're covered by who pays the rent, if it's coming from an agency, a homeless assistance agency, or something similar to the Public Housing Authority. Those might help you determine whether you're covered, but you can also contact these organizations. And for the Rural Housing Voucher Program, you would contact the USDA state office in Oklahoma. So there are a few types of evictions that are not covered by the moratorium. These are evictions filed before the moratorium took effect, so before March 27th. After the moratorium sunsets, so after July 25th, although remember there is a 30-day notice requirement that I discussed earlier, and you cannot give that notice until after the moratorium sunsets on July 25th. And another category is non-covered tenancies. So those are properties that are not considered covered under the Act, which are what we just talked about, those various property types that are covered. And evictions based on other reasons besides non-payment of rent or non-payment of other fees and charges. So this may seem like you can just come up with another reason for eviction, but it may not be that simple. Tenants will likely fight any eviction that is motivated whether wholly or in part by their non-payment of rent, whether or not that is the formal basis for the eviction. So just keep that in mind, that in the spirit of the Act, they really are trying to prevent any evictions that are based in any way on non-payment of rent. But there is this option if there are other reasons for eviction. Next, I will briefly talk about some of the eviction prevention funding that is available. This is mostly available to tenants to help them maintain or quickly find new housing, but you as landlords may benefit from them receiving this assistance. So this is additional funding that was authorized under the CARES Act, essentially adding funding to existing programs to help address the COVID-19 situation and the potential impact on loss of housing and risk of homelessness. This here is a summary of the homeless assistance grants, which can be used for prevention efforts to keep people from falling into homelessness if they lose their housing. Of course, there are a lot of various sources of funding in the Act. We have a memo on our website, which is listed at the end of these slides, that covers this type of funding and some of the other funding sources. But right now I'm just going to cover those that are related to homelessness and housing assistance. So you'll see here there are some allocations that are listed. The city is still in the process of figuring out what they will do with this money coming in. So at the moment, there isn't an answer for how it will be used and what will be available. But as soon as the city knows, I know they're going to release that information, make announcements, and potentially hold another webinar to answer questions about how this funding will be used. So just quickly going through this, first is the Emergency Solution Grant. This is basically rental assistance and financial assistance for rapidly rehousing people who have fallen into homelessness or preventing people from falling into homelessness. The first allocation, HUD allocated $1 billion of the total $4 billion under this. So there will be more allocated throughout the country as time goes on. But the first allocation, Tulsa City got just over $1 million, and the Oklahoma non-entitlement jurisdictions got $5.7 million. And again, this money locally has not been determined how it will be used, but this is money that's coming into the community to help with homelessness assistance. The Community Development Block Grant covers acquisition or rehabilitation of structures, construction, and this money can also be used for things like rental assistance and operating costs for shelters and similar services. The local allocation, HUD allocated $2 billion of the total $5 billion allowed, and so more will be allocated in the future. Tulsa City received just over $2 million. Tulsa County received $861,000, and Oklahoma non-entitlement jurisdictions received $8.6 million. And the last one listed here is the Housing Opportunities for People with AIDS, which provides housing assistance and services for low-income people living with HIV and AIDS. And the local allocations here, this is the only allocation for this money. Tulsa City received $86,000, and Oklahoma non-entitlement received $60,000. So again, these are the homeless assistance and prevention funds. Other funding may be available through the Act coming in to help you and your tenants, but this is directly related to eviction prevention and loss of housing. So now we'll talk about the mortgage forbearance, which is the way that the CARES Act is helping landowners and property owners, landlords through the Act. And this is covered through sections 422 and 4023 of the CARES Act. So for many homeowners with mortgages, there is help. But we do recommend that you first assess your situation. If you can pay your mortgage, it is recommended that you pay your mortgage. Forbearance does not mean that you don't owe that money. You will still owe the mortgage payments, and you'll have to work out with your loan servicer how those are repaid. But if you can't pay your mortgage, or you can only pay a portion, there is forbearance assistance available to certain properties. Depending on the type of property your loan secures, there are different provisions for this forbearance. Again, I mentioned earlier that the Act separates out single family and multifamily units. And so depending on which kind of loan you may have, what kind of property you may own, there are different provisions. So first we'll talk about which properties are covered. It's similar to what we talked about for the eviction moratorium. It includes most federally backed, federally owned loans or other programs that are connected to federal agencies. So these definitions are slightly different, but in general cover most of those federally backed loans. And just for some context, out of all the outstanding single family mortgages, roughly 70% are owned or backed by a federal agency. And for multifamily rental units, there's estimates that show about 50% of multifamily rental units are federally financed. So it does cover a large portion of those properties that are still under mortgages. So the process for request. none of the mortgage payment relief, these forbearances are automatic. You have to contact your mortgage servicer in order to request the assistance and find out what options are available. We recommend that when possible, using email or some sort of writing is preferable, so you have a record of your communications with your servicer. So here there is a little bit of a difference between the single family and multifamily. For the request for a single family, you just have to submit a request to your loan servicer affirming a financial hardship directly or indirectly related to COVID-19. The Act does not say whether the request needs to be in writing, but again, so you could do an oral request, but for your own records, writing may be preferred. The Act does prohibit servicers from requiring documentation of your hardship beyond your own attestation of financial hardship. So no, you do not need to provide any kind of documentation there when you are making the request. And there is no requirement for single family mortgages for you to be current on your loan. For multifamily mortgages, you also need to submit a request affirming financial hardship, but there is a requirement that you be current on payments as of February 1st, 2020. The duration also is different for these two types of properties. For the single family properties, the forbearance can last up to 360 days. The initial period is 180 days, and that can be extended for an additional 180 days upon request. And then for the multifamily, the forbearance can be up to 90 days, the initial period of 30 days, and that can be extended for 2 additional 30-day periods. Note here that any extension request must be made at least 15 days before the initial, the prior 30-day period ends. So you would need to keep that in mind. If you need to make an extension, you need to do it at least 15 days before the 30-day period is over. And do note that for both of these types of forbearances, the borrower can shorten or end the forbearance when it's no longer needed. So if you do request 180 days or 360 days and you don't end up meeting that, you can always end the forbearance. Just a few more provisions here to take note of. For the multifamily properties, loans for temporary financing, such as construction loans, are not eligible for forbearance. There's no loans excluded explicitly for single family properties. Fees and penalties, there's another difference here. For single family, the Act prohibits the lender from charging fees, penalties, or interest beyond those that would normally be scheduled under your existing loan contract. But for multifamily, there's no explicit prohibition on additional fees, penalties, or interest. But here, the covered period is the same for both single family and multifamily. It is the earlier of either the termination of the COVID-19 national emergency, so when there's a declaration of the emergency is over, or December 31st, 2020. So all requests for forbearance and extensions must happen during that time. Either the earlier of the termination of the emergency or December 31st. So finally, I'll talk quickly about the moratorium on foreclosures. This is under Section 4022 of the Act. So since this is under Section 4022, it only applies to single family mortgages, so properties that are 1 to 4 units. Again, this is the federally backed mortgages that we talked about for the forbearance. And there is an exception here for vacant or abandoned properties. So the foreclosure moratorium does not apply to those. And what this prevents is a servicer of a federally backed mortgage from initiating a judicial or non-judicial foreclosure, seeking a court order for a foreclosure judgment or order of sale, or holding a foreclosure sale or executing a foreclosure related eviction. So I believe this indicates that it prohibits continuation of foreclosures that has already been initiated. So it cannot actually conduct a foreclosure sale even if it had been in process before. And this, the duration of this is a little bit shorter than some of the other provisions we talked about. It expires on May 17th, 2020. So that covers most of the provisions that are related to landlords that might be relevant to you as landowners and landlords. I have a few things here just for more information. You can visit our website, Homebase. We have information related to COVID-19 and homelessness. And we also have an email here that you can send additional questions to. So now I want to open it up to any questions that came in.
Thank you, Alyssa. I did want to address a question that someone asked about how do I tell where the funding is being allocated in other places and other cities other than Tulsa. And I wanted to let them know that information is available online.
Yes.
You can look at the HUD website, hud.gov. There is also a website, hudexchange.info, and you can find out what cities, counties, and states are receiving and other, both ESG and CDBG. Moving on to the questions. We have a few questions about the eviction moratorium. First, does the CARES Act apply to evictions that were filed before March 27th, 2020?
No, as I mentioned, there are a few things that are not included, and those include evictions filed before the moratorium took effect. So anything before March 27th is not covered.
If a landlord covered by the CARES Act filed an eviction against a tenant before that March 27th date, can the landlord continue to charge late fees for non-payment of rent?
I don't know if the act specifically talks to that. I believe because it wouldn't be considered covered by the act. I might need to look into that a little bit more. It doesn't specifically say that. So I might, before I answer that definitively, I will look into that. So I'll take note of that question, and can I send that to you, Kristen, to send out?
That would be great. And we will include that answer along with the presentation slides and a recording of this presentation.
Yes.
Okay. And this may similarly be something that needs to be explored. If a landlord covered by the CARES Act filed an eviction against the tenant before March 27th, will they be able to proceed with the eviction and still qualify for the mortgage forbearance in the CARES Act?
My understanding, they're not related in that sense. If there was already an eviction taking place, that you are not able, there is a eviction moratorium for properties that receive a forbearance, but it's pretty similar to the general eviction moratorium. So to answer your question, I don't think that if you had one that is not covered by the act, so it took place before, you would be prohibited from seeking the forbearance.
Thank you. We had another question about forbearance. Are property taxes and insurance included in the forbearance, or will the homeowner still need to pay those during the forbearance period?
Right. So you might need to talk to your servicer about that. I mean, there's no additional fees that can be charged, but you will be responsible for those that are scheduled. That's probably something you need to work out with your mortgage servicer, whether or not those will be covered or included. So we recommend that you reach out to them and work out the details with them directly.
Thank you. And we got a question about why COC funding was not included as assistance for renters. I think my understanding is this funding is given directly to state and local governments and government entities, but that they may partner with community partners to use that funding in rental assistance. Is that correct?
Yes, there was no direct allocation related to the continuum of care program, but the funds under the ones that I discussed, can be used in a lot of similar ways in terms of eviction prevention and rental assistance. So um, the money can be used in a lot of similar ways that the money for continuum of care funds can be used.
And just to address concerns about that rental assistance, as was discussed in the presentation, allocations have been made to the city, county, and state.
Mm-hmm.
We are all working together now to explore how best to use that funding. That will include things like rental assistance, homelessness prevention, but also assisting the homeless population during this pandemic. So that will be ongoing. And once all those plans have been finalized, we will have another presentation for landlords, tenants, and community partners to give more detail about what that assistance will look like and how people can apply. So there is another question about a waiver for COC NOFA renewals this year. I think this may be a community partner question.
Right.
So
I'll
that
just quickly say that home base, we do have a pretty comprehensive document on our website related to those waivers. This, if you are a community partner and you are using those funds, continuum of care funds, we have a document that discusses the various waivers for that HUD recently released.
And we also had a question about a website for a list of contacts for rental assistance for tenants. I would encourage you to call 211. 211 is a great resource, not just for finding rental assistance programs you may qualify for, but also other programs you may qualify for, whether it's legal assistance, food assistance. It's just a great way to get in touch. Call one number and get a list of resources that can meet your various needs. We have another question. If a lease ends on April 30th on covered SFR under forbearance, and the homeowner wishes to end the lease, either to say sell the property or repair the property, can they give a 30-day notice to the tenant as the lease indicates and still take advantage of the forbearance? I think what's being asked here is if you get the forbearance but you still want to just end the lease, can you do that?
That might be another one I need to look a little bit more closely at. There is, as I mentioned, if you do take advantage of the forbearance, you are prevented from evicting tenants. So in that case, you may not be able to. So I believe that would be the case. I will look more closely at that and provide a more definitive answer.
And we had another question if this applies if you had filed before this happened. The act, again, did go into effect on March 27th. So if it was filed before that date, then the CARES Act doesn't apply. But if you had not filed, even if you might have been able to file before that date, it does apply now.
Right.
If there are no other questions, then we will move forward. Our next presenters are Blaine Frierson and Kelly Nope, who are Oklahoma attorneys. They will be explaining the current Oklahoma eviction moratorium and as well as landlord rights and responsibilities during this time.
All right. Thank you, Kristen, for organizing this webinar. And thank you for Alyssa for a brilliant presentation of the CARES Act and a very succinct and precise explanation of the Act. These are hard times for Oklahoma landlords and tenants, no doubt. Most of the national and local media coverage has to do with tenants and the plight of tenants. And my heart goes out to all tenants who are directly affected by the coronavirus, or maybe they're indirectly affected by losing their job or being furloughed, as is the case in Tulsa County with several large corporations, as you might read in the media. But at the same time, we have to realize that landlords are greatly affected by the coronavirus as well. When this act was first enacted on March 27th, I started to research what it meant and how it applied to local evictions. And what I found was that it directly affects about 80 to 90% of the properties that Kelly and I represent, because 80 to 90% of the properties that we represent are covered at least in part by a federally insured mortgage, or tenants that the landlord may want to file for non-payment on the other hand, are covered by Section 8 housing, Oklahoma Foundation housing, or other state or federal vouchers that assist with rent. And I'm receiving phone calls every day from landlords that tenants currently are not paying their rent. This comes from two places, my understanding, and this is really not legal so much as it is practical. What I'm hearing in the community, what I heard a lot in March is a lot of people were calling me and saying President Trump said you cannot file evictions. That is clearly untrue. That's not what he said, and what he did say is through this coronavirus act. The second one that I received a plethora of phone calls about was a local county commissioner who made a statement on the local media about the filing of evictions. But, and it was interpreted that she had said that you could not file evictions in Tulsa County. I researched that, and I found nothing to preclude the filing of evictions in Tulsa County based on the non-payment of rent, unless they're covered by the act that Alyssa spoke of. And all during this time, right from the 1st of March through now, people are filing evictions every day in Tulsa County. Now, the problem is more practical than it is legal, in the sense that the courthouse doors in Tulsa County are locked. And so to file an eviction, you have to either file it online by emailing the Tulsa County Small Claims Court clerk, or you have to file it through the mail. And I realize that a lot of you individual landlords may not have the documents that you need to file the eviction. And of course, then you have to have the court file stamp the summons or the eviction and send it back to you so that you may serve it. So it's more practical. There's currently not an Oklahoma moratorium on filing evictions, and there's currently not a Tulsa County moratorium on the filing of evictions. But again, it's more practical than legal, in the sense that last week when evictions were filed, the Tulsa Small Claims Court clerk was giving eviction dates for the first week of June. This week it may be the middle of June. I don't know. So you can file now, but you're not going to get a hearing date until sometime in June. And I realize that under Oklahoma law, as many of you are well aware, that landlords in Oklahoma are entitled to a hearing by statute within 10 days of filing an eviction. But currently, due to the coronavirus crisis, that's not the case. You're not going to get a 10-day eviction. You're going to get more like, right now, a month-and-a-half eviction. And in response to a question that I saw, either I heard online or I saw in the chat, in the chat room, all evictions filed before March 27th, whether you're a covered property or an uncovered property, may go to trial as normal. And most of these cases are set for the last 2 weeks of May. I have a couple of court dates in there, and I have about 150 cases set during the last 2 weeks of May. But again, the problem is, are we going to go to court the last 2 weeks of May? And that's not a legal question. It's a practical question, and your guess is truly as good as mine. But let's turn to the properties covered by the Act and those that are not covered by the Act. When I'm speaking, I'd like to be as simple as possible. Those covered by the Act are, number one, those that have or are financed, at least in part, by a federally insured mortgage. And number two, those properties who are attempting to file on persons receiving rental aid or rental assistance from a state or federal agency. Now, if this is the case and you're one of these properties that is covered by the Act, which Alyssa explained so well, you may not give a notice of the so-called 5-day notice to pay or quit under Oklahoma law. You may not give a notice until July the 26th. And the reason for that is that the bill was enacted, the Coronavirus Act, on March 27th. If you count the days, 120 days, that's up, as Alyssa and Kristen said, on July the 25th. So on July the 26th, you may give your pay to quit notice. But the problem is the Act further defines what kind of notice you may give. You may not give a 5-day notice to pay or quit, as we're accustomed to doing in the state of Oklahoma, but you have to give a 30-day notice to pay or quit. Now, practically speaking, I'm just going to tell you to take your 5-day notices and put them in your word processor and change that to a 30-day notice to pay or quit, which means basically if you give the notice for non-payment of rent, then your 30 days is up on or about August the 25th. Then after that point, you may go to the courthouse and file an eviction. And hopefully by that time, the courthouse doors will be open and you can file the eviction freely without hindrance of any type. But there is a question that has not been answered and will not be answered likely until the courts open back up the last 2 weeks of May. And the question is, when you give a 5-day notice to pay rent or quit under Oklahoma law, as you know, we may go ahead and file an eviction contemporaneously, which means we can file the eviction at the same time the notice was given. Now, the problem with that is that if they pay the rent within the 5 days, you have to dismiss the eviction. But we can go ahead and file an eviction. And so the question that I'm already receiving and I don't know the answer to is simply this. With the 30-day notice, may we file an eviction during the 30-day period? Now, clearly, a part of the answer is this. You may not execute on an eviction until August the 26th or after. Because first you got the 120-day moratorium, then you got the 30-day notice to pay or quit that you have to give. And then following that, you would request from the court an execution. And we have a very good local judge here in town that does evictions, the Honorable Judge Deborah Ludy Leach. And I'm sure she's not going to sign an execution until after that date in August. But can we go ahead and file for you? I don't know the answer, but I'm going down to the courthouse to ask her if the rules will be the same for the 30-day notice as they currently are for the 5-day notice to pay or quit in Oklahoma. Now, to those properties not covered by the Act, under Oklahoma law, you may proceed to eviction for non-payment of rent just as you've always done. That's the legal answer. But again, the practical answer is we're not getting court dates until early to mid-June. And so you're going to be a month and a half or 2 months out before you're going to be able to lock the tenant out for non-payment of rent. Now, let's deal with late fees for a minute. If you're filing an eviction for non-payment of rent, any covered property may not charge any late fees from March 27th, the date the bill was enacted, until July the 26th. So if you have a person that's even 4 to 6 months behind on his or her rent, you cannot get any late fees during this period if you're a covered property. And you must remain that. And I'm going to advise all my clients, if we're going to court in August, don't charge any late fees. Make it simple for the court. But for sure, legally, you cannot charge late fees if you're covered property during this period. Now, the second thing is, and I've gotten this question a lot already as well, if you're not a covered property, then in that event, may you charge late fees during this period? And my answer is emphatically yes, you may. Again, an uncovered property may proceed to eviction normally with respect to the act. When you're not covered by the act, you may proceed. Again, how long that eviction is going to be off in the future, we don't know. The city of Tulsa, and Chris received one question, which I would like to respond while I'm going through this brief part of the presentation, and that was, when should I file an eviction? I sent a letter to all of our clients, to mine and Kelly's clients, and said, I would recommend not filing an eviction until shortly before you expect to go to court. And the reason for that has little to do with the act and more to do with Oklahoma law. Because currently in Tulsa County, it is the presiding judge's position that you may not receive a judgment unless the rent was included in the 5-day notice. So if you gave your 5-day notice in March and it included rent through March, and you want us to file an eviction on your behalf now, and we get to court in late June, then you can't go back and say, well, they haven't paid April, May, and now June's rent as well. I want a judgment for that. Well, you can't do that because your notice only included rent through March. So I'm advising all of my clients, and I would urge you to do the same, is not file an eviction until after May 11th. Why do I say May 11th? Well, if the tenant has not paid his or her rent for May, on May the 6th, you may give a 5-day notice to pay or quit, and then we may file an eviction on May the 11th. And if they've not paid by that time, then you've included May's rent in the filing as well. And it's on the notice, and you may receive a judgment for the full period, but not just the period back March, April, and before that. So that again is what I'm advising my clients to do. Let's see here. Let's go next topic. Oh, just to be very clear, most all of you know that under Oklahoma law, landlords are entitled to a setting for an eviction 10 days from the date of filing. So if we file an eviction under Oklahoma law, we're guaranteed a hearing within 10 days of filing. But obviously, due to the coronavirus pandemic, the bad situation facing our country, and the rules of the Oklahoma Supreme Court, and locally as well, I don't believe that that's going to be in effect at all until quite some time in the future. So you file an eviction now, you're not guaranteed the 10-day hearing, you're going to get it a month and a half off under the court's current problems. Let me say something briefly back about those evictions filed before March 27th. There are a lot of them that the court dates got canceled in March. I only have about 150 that are set the last 2 weeks of May for hearing. But the problem there is, I talked to the Tulsa County Small Claims Court clerk about 2 or 3 weeks ago, and she said, Blaine, one day you are at court, there are 700 cases on the docket that day. 700 cases. And that's just incredible. I don't know, everybody here online that's familiar with Tulsa County knows we can't fit 700 people in the courtroom. We can't even fit 100 people in the courtroom. So the practicality of how that's going to play out and I have no idea. But those evictions filed before March 25th, strike that, March 27th, have mostly been set for the last 2 weeks of May, to my knowledge.
Blaine, we
Yes.
have just under 10 minutes left.
Okay.
So I would like to ask Kelly if she has a topic that she wants to cover and wants to add, so we can address questions and make sure we answer as many questions as possible for everyone.
No worries, no worries.
Thank you very much. Blaine covered the topic adequately well, certainly fine. And so I was just going to help him in fielding questions if you have any questions that were asked during the presentation.
All right, well, then let's use the remaining time that we have to cover some questions, because we have been getting several. I think one big question is, how can a landlord find out if they're covered by the CARES Act? And if they're not covered by the CARES Act, how can they show that to the judge if they've filed an eviction?
Well, I think Alyssa covered that very well. If the landlord is receiving Section 8 funds or from a voucher program, obviously they're covered. They can look at their mortgage documents to see if a federal entity is involved in their mortgage. Then they would be a covered property in that instance. If they don't take any type of vouchers or Section 8 monies, or if their mortgage documents only show a private lending entity, then it's very likely that they are not a covered property. And possibly, we haven't gotten this established definitively, but possibly they could bring a copy of their mortgage. I know that sounds a little bit tedious, but that would be what I would suggest. And perhaps we will get further guidance about that issue from the court when the court reopens in May.
And if I may, Brian Huddleston on the chat room, a very well-respected colleague of mine and local attorney, is kind of addressing that issue in the chat room. He says probably going to need to bring a copy of your mortgage to show it, at court or whatever, or consult, an attorney about that and see if your mortgage is actually one of the federal ones that are covered.
We've gotten a similar question of how a tenant can find out if their landlord is covered. To answer that, the guidance that we've been putting out at the city is ask your landlord if they are covered. If your landlord should be able to find out. If they're not telling you, we are working with both local and national resources to put together a database or a resource to help tenants find out. That just isn't in place at this moment. We had a question about serving an eviction notice. If a tenant is served with an eviction notice while they are recovering from COVID-19 or hospitalized due to COVID-19, is there someone who will help them file a reasonable accommodation, or is a reasonable accommodation even possible in that case?
I would respond by saying they need to consult an attorney, definitely. If they qualify and they don't have sufficient income, they may call legal aid. In Oklahoma City, they have an 800 number they can call, which in that case, they may be referred to a local attorney in Tulsa for legal aid. And there are 7 attorneys in Tulsa that work with evictions. And I would say that's who they need to consult about whether or not that's a reasonable accommodation.
We've gotten a few more questions about whether the CARES Act applies to an individual. So and I think some clarification could be helpful here. When we talk about the CARES Act applying, we are talking about that specific property, correct? Not the landlord who may own multiple properties, some of which may be covered and some of which wouldn't.
Exactly. And I have two clients in Tulsa who own about 5 or 6 properties, and part of their properties are covered and some are not. And so, yes, it only relates to the specific property.
We've also gotten questions from landlords that if their tenants ask them if the CARES Act applies to them, are they allowed to not tell them that the CARES Act applies?
I think that under the spirit of the law, the landlord ought to tell them, the landlord or owner of the property. And I've not found one landlord that's not willing to share that with the tenants. And so I think that's something that they're going to be pretty honest about, to be honest. So.
Well, and we did have one question along those same lines. If the landlord does not want to produce a mortgage or other documentation showing the CARES Act doesn't apply to them, can they be required to do so when filing an eviction?
Well, I think there's a possibility that the court may require an affidavit from the landlord in order to establish that the CARES Act doesn't apply. I think that certainly it may be done on a case-by-case basis, but whatever the court requires for you to produce in order to file an eviction, you'll be required to produce it, obviously.
And we have a question again about mortgage documents. If they bring the document to court, does it become public record? But I think it's accurate to say that a mortgage is already a public record because it would be filed with the Register of Deeds.
Exactly. All the mortgages are filed with the county clerk's office, so they are a matter of public record.
Okay. We had a question about, you did mention that as evictions are being filed, but hearings are not being held, some court dates have been continued. If someone filed an eviction and the hearing date has been continued due to the moratorium, does the landlord need to serve a new notice to the tenant of the continued court date?
This issue came up before even the act was enacted, and I called the court clerk and said, "Do we need to serve them all again?" And at that time, they said no. They said they should consult the media and so forth, and then consult the Oklahoma State Court Network, oscn.net. But I don't know if that's going to change or not.
So if a landlord is not notifying a tenant of a new court date, where can the tenant find out if their court date has changed?
Well, the tenant can look on the Oklahoma Supreme Court Network, oscn.net, and see the court dockets and the new court dates. And in addition to that, obviously they could call the small claims court and ask when the new court date would be.
We do have one comment from Brian Huddleston, who I believe is an attorney in Tulsa, that he has heard from the court in Tulsa that an alias summons would be needed.
If the tenant doesn't appear?
Well, if there is a
new court.
If there is a continuance, I believe.
Okay.
Thank you for that. I appreciate that.
We also have another question about, again, when properties are covered. If there is a property where you have multiple tenants and some receive Section 8 housing choice vouchers while others don't, is the entire property covered by the CARES Act, or can the landlord file an eviction against those tenants who do not receive Section 8?
That may be more of a question for Alyssa, but I'm advising my clients that they may file on those tenants who do not receive state or federal aid for rental assistance.
Sorry, this is Alyssa. I, again, am not an attorney in the sense of practicing there, but when I read the act, it says a covered property means any property that participates in a covered housing program. So to me, this is kind of where there's maybe a little bit of a gray area, but it seems to include the entire property in kind of that language. But perhaps Blaine and I can chat offline and kind of figure that out and send that out, because it's a little unclear. I would think, just because of the way it's phrased, covered property, any property that participates in one of these programs. So if you're receiving any kind of vouchers, it might apply. So we'll get back to people about that.
I tend to agree with your interpretation, Alyssa, that if you are receiving Section 8 vouchers on it's a multifamily property, that you would be covered under the Act.
Kristen?
Yes.
Hey, I have two questions that I took off of your chart, which I think would have general appeal to landlords. May I address those?
Absolutely.
The first one is, it was asked if a tenant is breaching a lease, was basically the question. Can I still evict them? Well, under those covered by the Act and those not covered by the Act, in Oklahoma, you may still proceed to eviction based on breach of lease. In Oklahoma, we have two modes in which we do that. One is a 1015, which basically says if you don't get the dog out of your property in 10 days, we're going to cancel the lease. It's hereby canceled in 15 days. So for breach of lease, in that instance, you may do it. Also, we have an immediate notice whereby there's the actual physical harm to a person or property, or there is the threat of actual physical harm to a person or property. You may proceed to an eviction within 24 hours. And even those properties covered by the Act, it's my interpretation, may proceed under those two auspices. But here, it's important to say, and I've seen a letter from a national tenants' right organization, and I tend to agree with them. You can't have a tenant that's not paying their rent and want to get rid of them for not paying their rent, but sue them under the guise of a breach of lease. I don't think the local judge would stand for that. And so I think you better have a good reason to terminate the lease. Number two, Kristen has told me there are a lot of calls coming to the city of Tulsa about constructive evictions, wrongful evictions, where landlords are changing the locks without benefit of court, or they're cutting off utilities without benefit of a court order. You cannot do that in Oklahoma. And as Brian has pointed out over here on the chat room, you're subject to 2 times the actual damages of the tenant landlord. You're subject to 2 times. So if the tenant has $1,000 in property, that they lose, furniture, then you can be sued and they can recover 2 times that property value, or $2,000. It's something that legally and ethically you should not be doing at this time, is changing the locks without benefit of an eviction. That's all I had.
Well, I will add, if for those tenants and community partners we have, if there's been a threat of a constructive or unlawful eviction, or someone has experienced that, please call 211. We do have resources that can assist tenants where that's occurred. Finally, as we've run out of time, one of the final things I wanted to mention is I know there is definitely frustration for landlords who have had their cases delayed by the Eviction Moratorium and potentially further delayed by the CARES Act. At this time, we do have the early settlement mediation program that is available. They are going to start holding online mediations April 20th. So that means you can start working on resolving any disputes you might have with your tenants before the court opens, and hopefully come to a settlement agreement that avoids any more delay or the cost of an eviction filing. We are also actively working on developing those rental assistance resources, and hope that soon we will be able to give more guidance on what those resources are, who qualifies, and how to apply. So while I understand that the delay that's occurred is frustrating, I do want to assure you that we're doing what we can to get resources in place to help in the interim and to relieve the financial hardship that's occurred for both landlords and tenants. So I want to thank everyone for participating. We will be making a recording of this available online. Alyssa's slides will also be made available online, and we will look for answers to those questions that we couldn't address here today. That will be posted on the Away Home for Tulsa website. It will also be on the City of Tulsa's housing website. So thank you very much for your participation.